Among the assurances offered by convention advocates that bad amendments can't happen is their claim that Congress can refuse to send what they call unauthorized amendments out for ratification. This claim is too silly to receive much consideration. Unauthorized by whom? There is no such thing as an unauthorized amendment. Once a convention is called, it is authorized to propose whatever it chooses. If anyone offers you this foolish argument, ask him to show you where in the Constitution Congress is given the power to withhold an amendment proposed by a convention from the ratification process. No such power exists. It is a creation by the same spin artists who have created the other myths and misconceptions about the so-called limited power of a con-con. Another of the spin artists' claims is that the Supreme Court can strike down any proposed amendment which exceeds a convention's authority. This is as asinine as the previous one. It wrongly assumes the existence of such a thing as an unauthorized amendment. Two Supreme Court justices quoted above have said that there is no such thing. Need we say more? If this argument is offered to you, it is easy to ask where in the Constitution this power is given. It isn't. Imagine yourself as a state legislator in 1787 who voted to send delegates to the Philadelphia Convention. In voting to send them, you helped place limits upon their power. They could only propose changes in the Articles of Confederation. They have no power to abolish them. Believing that these limits are effective, you vote eagerly to send the delegates. After all, you reason if we don't like the work product of the convention, we can refuse to ratify it, especially since Congress and every state legislature must agree. It clearly says so in Article 13 of the Articles of Confederation. Much to your surprise, you are wrong on both points. The convention violates its instructions by writing a new constitution. To compound the surprise, you never had an opportunity to approve or disapprove of the new Constitution on the floor of your legislature. Separate bodies met in the several states to consider ratification because the convention changed the rules of ratification, also without authority to do so, and the usurpation of authority prevailed. Our Constitution, unlike the Articles of Confederation, is not a failure. It works well when its provisions are observed, and it needs no revision. Even under the current ratification procedures in Article 5, if they are not changed by a newly sitting convention, a legislature is not guaranteed to have a proposed amendment come before it for ratification. Take the example of the 21st Amendment, which was adopted to repeal prohibition. The last state completing ratification was Utah, a state whose political and religious demographics made it the least likely to approve the repeal of prohibition. There is little likelihood that the Utah legislature would have approved the repeal if it had been given an opportunity to vote on it. But the Utah legislature never got to consider the amendment. Congress proposed the 21st Amendment and provided that it would be ratified by conventions assembled in the states for that purpose. Congress wrote the rules and created a process for selecting the delegates to ratifying conventions in each state in such a way that the delegate selection process was biased to favor the repeal, so that even in Utah, the amendment was approved. It was all done in accord with Article 5 constitutional procedures. This could happen again if a convention is called today. The proponents of a convention have used a multiplicity of tactics to get legislative support for their project. In some cases, a prominent national political figure will contact legislators in his home state, seeking their support for the convention. He always claims only to want a balanced federal budget. He urges them not to vote to rescind existing convention applications, using promises of personal political help for the state legislature. These national political figures seek and get commitments from legislators, especially key committee chairmen, to oppose the rescission measures. In some cases, the appeal is on a very personal basis, in which the national political figure will claim that a rescission of con applications will hurt him personally and politically. These appeals are tempting to many legislators. But there is more at stake than promises of personal political help and personal pleas. The integrity and the very existence of the Constitution as we know it could be in jeopardy if a convention is called. This is not hype nor mere rhetoric. It is the collective wisdom of the nation's leading judges and legal scholars. This is a time for introspection and commitment to a way of government and a way of life. It is a time to stand straight and firm to repeal all convention applications. Too many brave men and women have sacrificed too much in defense of their country and their Constitution to have it put in jeopardy by the intentional or inadvertent calling of a constitutional convention. The decision to preserve the Constitution or to leave it in the jeopardy described by Chief Justice Burger and other scholars is your decision. As a legislator, you will never make a more important one. Will you put the Constitution and principles above mere personal or political considerations? All extant applications for a con must be repealed. Please stand up for the Constitution and for America. These leading legal scholars agree. No one can mandate a limited, single-issue constitutional convention.